Can a landlord enter without notice in Florida? What the law actually allows. In Florida's fast-moving rental market, questions about privacy and access surface often, especially as property owners balance maintenance obligations with tenants' rights. Whether it is a repair request, a showing to prospective renters, or a concern raised by a neighbor, the issue of landlord entry without notice sits at the center of many disputes. The answer, as Florida law makes clear, is nuanced and highly dependent on circumstance. The legal baseline for landlord entry in Florida. Florida law generally prioritizes a tenant's right to quiet enjoyment of their home. Under Florida Statute 83.53, landlords may enter a rental unit only for specific reasons and typically must provide reasonable notice before doing so. In most situations, reasonable notice is defined as at least 12 hours, and entry must occur at a reasonable time, usually during normal business hours. This standard applies whether the landlord intends to make repairs, conduct inspections, or show the property to prospective buyers or tenants. Without notice, entry is not the norm. In fact, it is the exception. When entry without notice is allowed. There are limited circumstances in which Florida law permits a landlord to enter a rental unit without prior notice. These situations are tied to urgency and safety rather than convenience. Emergencies. If an emergency threatens life, health, or property, a landlord may enter immediately. Examples include a burst pipe, a fire risk, or a strong smell of gas. The law recognizes that delaying entry in these situations could result in significant harm. Tenant absence or abandonment. If a tenant has abandoned the property or is absent for an extended period and the landlord reasonably believes the unit is unsecured or at risk, entry may be permitted. Determining abandonment, however, is fact-specific and often contested. Tenant consent at the time of entry. If a tenant explicitly agrees to immediate entry, notice is not required. This often occurs when tenants request urgent repairs and coordinate directly with the landlord or property manager. What does not qualify as an emergency? Routine maintenance, scheduled inspections, appraisals, and property showings do not qualify as emergencies under Florida law. Even well-intentioned reasons do not override the notice requirement. This distinction is particularly important in Pinellas County, where many rental properties are condominiums or older coastal homes. Routine issues such as HVAC servicing or roof evaluations following storms still require notice unless an immediate danger exists. Local context, Pinellas County considerations. In Pinellas County, where rental demand remains strong and turnover is frequent, disputes over access are not uncommon. Coastal weather events and aging housing stock increase the likelihood of repairs, but local code enforcement expectations do not eliminate tenant notice rights. Property owners operating in cities like St. Petersburg, Clearwater, or Seminole often manage multiple units, making standardized entry procedures essential. Many professional landlords in the area rely on written notice policies to avoid misunderstandings and complaints. Consequences of improper entry. Entering a rental unit without proper notice can expose landlords to legal risk. Tenants may claim violations of privacy or interference with quiet enjoyment. In extreme cases, repeated unauthorized entry can support a tenant's decision to terminate a lease or pursue legal remedies. For homeowners considering converting properties into rentals, this is a critical operational detail. Buyers evaluating income properties should also factor management practices into their due diligence. A clear takeaway for Florida landlords and tenants. Florida law draws a firm line between access and privacy. Outside of true emergencies or clear abandonment, landlords are expected to provide notice before entering a rental unit. The rule protects tenants while still allowing landlords to fulfill their legal obligations to maintain safe, habitable housing. In a competitive market like Pinellas County, understanding and respecting these boundaries is not just a legal requirement, it is a practical necessity for avoiding conflict and preserving property value and reputation.